majority of us have overruled the judgment in E.V. Chinnaiya. We have held that subclassification of the scheduled caste for the purposes of reservation is permissible. Scheduled castes notified by the President under Article 341 are a heterogeneous class where groups within the class suffer from varying degrees of social backwardness. The struggles that the class faces do not disappear with the representation in the lower grades. The endeavor is to ensure true and effective representation of the socially backward classes across posts. Scheduled castes in specific localities. For example, in the state of Madhya Pradesh, of the 25 castes, only 9 are scheduled castes throughout the state. The criteria used to identify the scheduled castes itself indicates that the endeavor was not to include all castes that suffered from identical forms of untouchability. The state, in exercise of the power under Articles 15.4 and 16.4, can further classify the scheduled castes. The first prong of the test for subclassification is whether the scheduled castes form a homogeneous group, integrated class for all purposes. We have held above that even if Article 341 creates a deeming fiction, the provision does not create an integrated class that cannot be further subclassified. The provision only puts certain castes or groups or parts of them into a group called the scheduled castes. The castes or groups within the scheduled castes form an integrated class for the limited purpose of constitutional identification. They do not form an integrated class for any other purpose. We have also established through historical and empirical evidence that the scheduled castes notified by the President under Article 341 are a heterogeneous class where groups within the class suffer from varying degrees of social backwardness. Thus, the first test is satisfied. The state, in exercise of its power under Articles 15 and 16, is free to identify the different degrees of social backwardness and provide special provisions such as reservation to achieve the specific degree of harm identified. If the scheduled castes are not similarly situated for the purpose of the law or the specific harm identified, there is nothing in Articles 15, 16, and 341 which prevents the state from applying the principle of subclassification of the class. Thus, the scheduled castes can be further classified if A, there is a rational principle for differentiation, and B, if the rational principle is a nexus with the purpose of subclassification. The scope of subclassification of the scheduled castes is summarized below. A. Since the purpose of Articles 15.4 and 16.4 is to ensure equality of opportunity of the socially backward classes, the criterion for subclassification within a class, be it the other backward classes or the scheduled castes or tribes, must be an indicator of social backwardness, and B. Since the state can use any yardstick to determine inter se backwardness, it is not necessary that the criteria for subclassification and the criteria used to distinguish the class from the other classes must be the same. That is, if the criteria for recognizing the scheduled caste as a backward class is untouchability, it is not necessary that the group can be subclassified only if there is inter se backwardness due to the same identity, that is untouchability. The course of action adopted by the state is subject to judicial review when faced with a constitutional challenge. Where the action is challenged, the state will have to justify the basis of its action, the basis of the subclassification, and the model which has been followed will have to be justified on the basis of empirical data gathered by the state. In other words, while the state may embark on an exercise of subclassification, it must do so on the basis of quantifiable and demonstrable data bearing on the levels of backwardness and representation in the services of the state. It cannot, in other words, merely act on its whims or as a matter of political expediency. The decision of the state is amenable to judicial review. A, the objective of any form of affirmative action, including subclassification, is to provide substantive equality of opportunity for the backward classes. The state can subclassify inter alia based on inadequate representation of certain castes. B, the state must collect data on the inadequacy of representation in the services of the state. The inference in Nagaraj that CADA must be taken as a unit to determine inadequacy of representation, inadequacy of reservation, based on the observations in R.K. Savarwal, in our respectful opinion, is misplaced. The cadre as a unit was considered only for the purpose of preparation of rosters to draw a balance between the reserved and open seats. This court did not hold that the cadre must be used as a unit for the purpose of determining the adequacy of representation. And C, conventionally, the state has assessed if the class is adequately represented by comparing the representation of the class in the services to the total population of the state. However, adequacy of representation, when determined purely from a numerical perspective, without accounting for factors such as representation vis-a-vis posts, would dilute the purpose of the provision. The objective of Article 16.4 is to ensure effective representation of the class in the services of the state across posts and grades. Classes which are socially backward occupy the lowest of the social strata, primarily because of the traditional occupation accorded to the class by social rules. For example, certain Dalit castes are regarded as scavenger castes. Even with the provision for reservation, it is very difficult for the backward classes to share the traditional occupation that is ascribed to them by society and optimize the opportunities even at the lowest levels. The struggles that the class faces do not disappear with the representation in the lower grades. The endeavor is to ensure true and effective representation of the socially backward classes across posts. Thus, for the above reasons, the holding in Chinaya that subclassification of the scheduled castes is impermissible is overruled. The scope and limits of subclassification of the scheduled castes shall be as prescribed in the judgment. The registry is directed to obtain administrative instructions from the Chief Justice for placing the matters before an appropriate